morning, ladies and gentlemen, and thank you for tuning in to Lakeside News this Monday morning. This is Janice Lim, live from the Lakeside studio. Today's headlines concerns the law of rape in Malaysia, and we have speakers here today ready to help us understand more about this topic. We look forward to hearing about the issues in this area of law and the reforms that can be proposed, so do stay tuned. Audrey, on to you first to discuss the current standing laws in Malaysia.
Thank you, Janice. Now, generally, rape can be defined as sexual intercourse against one's will or without their consent. In Malaysia, laws criminalizing sexual offences such as rape can be found in the Penal Code, Section 375, which provides that sexual intercourse is rape if it falls within the circumstances listed out in Section 375 A to G. These circumstances relate to situations whereby there is a lack of consent, where consent is obtained through unlawful means, or where consent is given is rendered invalid. The case of Rex against Abu Qasim bin Babu has illustrated that, as consent requires an active will in the mind of a person, consent given under duress, fear, or even mere coercion cannot be said to be valid. Furthermore, it must be noted that, as per Section 375G, sexual intercourse with a girl under the age of 16 amounts to rape, irrespective of the presence of consent. Apart from the circumstances listed in Section 375A to G of the Penal Code, reference has also been made to Section 90, which provides that consent cannot be given by persons put under fear of injury, a misconception of fact, or is in a state of unsoundness of mind. It is explained in the Penal Code that penetration would suffice to constitute the sexual intercourse necessary for the offence of rape. Nasrul Anwar bin Abdul Samad against public prosecutor makes clear that the penetration must be done by the penis of the accused. Here, any slight penetration of the vagina would suffice, as illustrated in Sidin bin Ludan against public prosecutor. This penetration need not be substantial, and as seen in Xiong Hui against public prosecutor, ejaculation or a tear in the hymen does not need to be proven to show penetration. The Penal Code also criminalizes other acts involving rape and or sexual offences, such as sections 375A, 375B, and 376A, which deals with husband causing hurt in order to have sexual intercourse, gang rape, and incest, respectively. And now I'll be handing off my remaining time to Florence, who shall be discussing gender-specific language.
Thank you, Audrey, and now we'll move on to look at the first criticism on gender-specific language. Under this, the first issue that can be observed is on transgender rapists and transgender victims. Similar to Singapore and India, the genders of the offender and victim of rape under Malaysian law are specific, as the terms man and woman are clearly stated in the provision. Hence, there is a gap in the law in relation to sexual offences or rape committed by or against a transgender person. On the other hand, the current English law on rape has changed its position due to the amendment in the Sexual Offences Act 2003, where the mention of gender has been removed from the definitions of rape. Here, reference to a man and woman in Section 1 have been replaced by that of a person. In addition, in the Australian case of Crown against Cogley, the Supreme Court of Victoria held that whether the victim was a man or a woman, or a person who had the physical appearance or physical attributes of a man or a woman is not relevant in determining whether a crime has been committed in such circumstances. The second issue is on male rape. Rape is typically seen as a crime committed solely against women. However, in recent years, some brave men and boys have come forward to admit that they have been victims of rape and sexual abuse. The Centers for Disease Control and Prevention in the United States shows that among 17 male victims of their study who were raped by being penetrated, 86.5% reported that the perpetrators were male. In Malaysia, perpetrators of rape against men cannot fall under Section 375. Instead, they will be subject to Section 377C, which concerns carnal intercourse without consent. Hence, if a man comes forward, he will be told that what happened to him was not rape, but merely an unnatural offence which carries a lesser penalty. In England and Wales, the Criminal Justice and Public Order Act 1994 was the very first act to criminalize rape against males. This act is partially gender-neutral in that it substituted the words "it is an offence for a man to rape a woman" with "it is an offence for a man to commit rape." The first case in the UK involving rape against a male is Crown against Richards, which the successful convictions of the accused suggest that the aims of Section 142 of the Criminal Justice and Public Order Act have been achieved, bringing the offence of male rape in line with female rape. Now, the law of rape is governed by Section 1 of the Sexual Offences Act 2003, which also provides that both men and women can be raped as long as the offender intentionally penetrates the vagina, anus, or mouth of another person, regardless of whether the organs belong to a he or she. Thus, it is submitted that Malaysian rape laws should also consider men as victims of rape instead of categorizing such as under carnal intercourse, under which the accused suffers a more lenient penalty. The third issue is, can a woman commit rape? Well, there's no doubt that a woman cannot commit a rape based on Malaysian law unless she had undergone gender reassignment operation to become a he. Even still, the medical reports will not be sufficient as a court declaration affirming the change of gender is required, and this can be seen in the case of Tan Pei Ying and Ketua Pengarah Jabatan Pendaftaran Negara. It is only after obtaining this declaration that a female-to-male transgender person with an artificial but well-functioning penis can be said to commit rape. This presents a loophole as a female-to-male transgender rapist may simply not apply for a gender reassignment declaration. By virtue of their gender of birth being female, they will not be legally considered a male and cannot therefore commit rape. Apart from that, Dr. Muhammad Ismail bin Haji Muhammad Yunus proposed that Section 375 of the Malaysian Penal Code should be reformed by referring to the England and Wales Sexual Offences Act 2003, which the gender-specific terms, namely a man and a woman, should be replaced with the gender-neutral terms a person. This would effectively include men, women, and also transgender individuals and expand the definitions of rape under Section 375. Moving on to look at the criticism on marital rape, I will now pass the time to Chloe to address this. Thank you.
Thank you, Florence.
Exception to Section 375 provides that sexual intercourse by a man with his own wife, by a marriage which is valid under any written law for the time being enforced, or is recognized in Malaysia as valid, is not rape. This means that, in Malaysia, a man cannot be guilty of raping his own wife. This view can be traced back to English origins, particularly the work of Sir Matthew Hale in Historia Passitorum Coloni. In his writings, he stated that, by virtue of matrimonial consent, a wife gives her husband consent which she cannot retract. This view, however, is largely seen as unsuitable for modern times. In the landmark decision of Crown against R, the House of Lords unanimously denounced this principle. Lord Keith stated that marriage is in modern times regarded as a partnership of equals, and no longer one in which the wife must be the subservient chattel of the husband. And, in modern times, any reasonable person must regard this conception as quite unacceptable. Although England and Wales have moved on from this notion, Malaysia continues to exclude forced sexual intercourse between a man and his wife from the definition of rape. In 2007, Parliament amended the Penal Code, adding Section 375A to criminalize such acts, but only when the husband causes hurt or fear thereof in order to have sexual intercourse. For this reason, Section 375A is widely regarded as Parliament's attempt to walk an unhappily happy middle way in light of differences in public opinion. However, this provision fails to protect wives who, in the absence of hurt, are coerced into non-consensual sexual intercourse. It is submitted that Malaysia should follow in the footsteps of the UK in criminalizing marital rape and recognize that irretractable consent by virtue of marriage is an archaic notion. As Professor Glanville Williams put it, when a woman, regardless of matrimonial status, says no, she should be able to do so with the backing of the law. Doing this would be in line with the spirit of Article 8(1) of the Federal Constitution, under which women, regardless of marital status, are to be regarded as equals. Moreover, it is argued that rape towards one's spouse is equally psychologically impactful, if not more so, than rape by strangers due to the mutual trust and confidence present in matrimonial relationships. Therefore, it is undesirable that the law provides no redress in this regard. Accordingly, it is proposed that the exception to Section 375A be deleted and marital rape recognized in Malaysia. Furthermore, due to the relationship of trust present in marriage, it should also be possible for marital rape to be classified under Section 376 to subsection F, so as to constitute a harsher punishment. Such reforms would bring rape laws in Malaysia more in line with international standards. Numerous Southeast Asian countries, such as Philippines and Thailand, have criminalized marital rape over a decade ago. Likewise, Singapore is currently in the process of removing their marital rape exception. Hence, it is submitted that it is high time for Malaysia to follow in the footsteps of our neighbors. On to you, Janice, on issue of vaginal rape.
In Malaysia, Vaginal penetration by the penis, however slight, is sufficient to constitute sexual intercourse for the offense of rape. There is no necessity to show a tear in the hymen or ejaculation of semen into the vagina. However, sexual intercourse under Section 375 of the Malaysian Penal Code only refers to penetration by a man's penis into a woman's vagina, and they will constitute rape if it falls under the circumstances provided. As such, non-consensual anal or oral penetration, also known as sodomy, is not recognized as rape. This traditional idea of sexual intercourse was influenced by Malaysia's roots when under the colonization of the United Kingdom. Then, same-sex conduct and sodomy in its former colonies were criminalized because they were considered to be degrading in nature. Furthermore, the origins of the offense of rape was concerned with the protection of virginity, which is characterized by tearing of the hymen in the vagina. However, it is clear that they have moved on from this draconian position. In Malaysia, anal and oral penetration are provided for in two other provisions. Section 377A provides for carnal intercourse against the order of nature, and Section 377C for the same but without consent. The absence of the expression of consent in Section 377A implies that even consenting hetero and homosexual couples could be criminalized. This is problematic in many aspects. Firstly, all other sexual offenses providing for sexual intercourse is only referring to vaginal penetration. Taking the offense of husband causing hurt in order to have sexual intercourse or gang rape as examples, the accused would need to have carried out vaginal penetration only to be convicted. It is mentally degrading to the victim for the accused to have non-consensually penetrated, yet not be convicted as a rapist. Another issue is the difference in punishment. While the offense of rape under different circumstances provides for a minimum of 10 and a maximum of 30 years in prison, carnal intercourse without consent provides for 5 to 20 years only. Again, it is illogical to only class non-consensual penetration to the vagina as rape and possibly give allowance for a perpetrator to get off with a lesser sentence. In addition, there is no reason why anal and oral intercourse is criminalized under a different provision, except the fact that it was a product of colonization. Moreover, there is a lack of explanation to the difference between punishments for non-consensual and consensual carnal intercourse. The minimum 5-year jail sentence for the former is barely a reasonable distinction, and this is also problematic. It again highlights the redundancy of separating anal and oral penetration from vaginal penetration and the embedded colonial concept of what is natural and unnatural sex. Malaysia can follow in the footsteps of many examples to catch up with modern law. In the United Kingdom, the First Amendment to Section 1 of the Sexual Offences Act added anal penetration to be recognized as rape, and subsequently replaced in 2003, it expanded to recognize oral penetration as well. Similarly, in fellow Commonwealth countries like India and New Zealand, sexual intercourse now includes penetration by the penis, other bodily parts or objects into the vagina, anus, or mouth. In short, Malaysia should urgently take steps to broaden Section 375 by amendment to define sexual intercourse as vaginal, anal, and oral penetration, or remove sexual intercourse as a whole. At the same time, sodomy laws regarded as carnal intercourse should be repealed because of its lack of necessity and to supplement modern and sufficient laws on the offense of rape.
Thank you, Janice. Typically, offences under criminal law can be broken up into the physical and the mental element. These are known as the actus reus and the mens rea, respectively. However, the definition of the offence of rape under Section 375 merely lists specific circumstances in which sexual intercourse amounts to rape. Although subsections C and D make some references to the mental state of the accused, Section 375 does not explicitly lay out a requisite mens rea. This is similar to the law in Singapore and India. With that being said, a mental element has been implied into law by the courts through numerous case law. This can be seen in the case of Razi bin Rami, where the fact that the accused knew his victim was below the age of consent was considered in charging him under Section 375G. In other words, the mens rea of knowledge was affixed to Section 375. Teo Eng Chan and others, the court also considered the accused's mental state of mind, albeit on a different ground. Here, although it was not established on the facts, the courts acknowledged that the general defense of mistake under Section 79 could be used in arguing that the accused had been mistaken as to the presence of consent. However, this places the burden of proof onto the accused. In other words, the accused must prove his innocence. This does not fall in line with the fundamental characteristic of criminal law, whereby one is presumed innocent until he is proven guilty. Accordingly, it is recommended that the requirement of a mental element, as applied by the courts, should be expressly codified into Section 375. To do so, it is suggested that Malaysia adopt a similar definition of rape as that found in Sexual Offences Act 2003 of England and Wales. Here, the accused shall not be guilty of rape if he had reasonably believed that there was consent. Doing so will provide clarity as to the presence of a requisite mental element, as well as place the burden on the prosecution to show that the mental element was indeed present. Next, on to Audrey on incest rape.
Thank you, Chloe. The crime of incest is defined under Section 376A as sexual intercourse with another person whose relationship to them is such that they are not lawfully permitted to marry. Under the Penal Code, incest does not fall under the category of rape. However, Section 376B subsection 2 acknowledges incest without consent and has been utilized in cases of rape involving siblings and fathers and daughters. The Malaysian Penal Code generally prescribes similar penalties for the crime of rape and incestual rape. The penalty for rape under Section 376 subsection 1 is imprisonment and may extend to 20 years. However, if the rape falls within the categories under Section 376 subsection 2, a minimum penalty of 10 years imprisonment and whipping is imposed. The sentence may also extend to 30 years. And similarly, incest under Section 376B is punishable with a minimum jail term of 10 years and whipping that may also extend to 30 years. Notably, the law in Malaysia treats the crime of rape and incestual rape as equally grave. However, they differ in one regard, that is, the death penalty. Under Section 376, subsection 4, if the accused in committing the rape causes the death of the victim, they may be punished with the death penalty. Contrast this with the provision on incest, which does not provide such a punishment. Therefore, hypothetically, if death were to be caused to a victim of incestuous rape, the only recourse would be through rape under Section 376, subsection 4. It is therefore proposed that incestuous rape, which results in death, should be given its own offence in the Penal Code instead of relying on Section 376, subsection 4, and should be punishable by death. This stance is supported by the former director of the Federal Criminal Investigation Department, Dato' Ismail Cherus. He opined that perpetrators of incestuous rape, even when it does not cause the death of the victim, should be liable to the death penalty or life imprisonment. In line with this, it is submitted that even graver cases of incestual rape, such as one involving death, should warrant the death penalty. However, this proposal is not without criticism. Professor Dr. Kushnal Viktuk has raised concerns over the effects of a death penalty on a victim's state of mind, particularly that the potential toll on the victim's conscience may prevent them from coming forward. This is because a victim may feel responsible for the deaths of the accused. He further stated that such a psychological setup would obviously cause the victim of incest to be manipulated into silence. Nevertheless, it is arguable that the imposition of the death penalty for extreme cases of incestual rape is that of necessity. In fact, there have been propositions that the act of incest itself warrants a harsh punishment as it violates the moral order of the world. The scholar Jennifer Tampkin stated, "Women living in or in contact with fathers, brothers need to know that sex between them is not and never will be on the agenda. It is fitting, therefore, for the criminal law to place its weight behind that boundary and endeavor thereby to protect the individual's safety in the family situation." Hence, in cases of incestuous rape involving death, there is further reason for the implementation of a death penalty to protect potential victims and to act as a deterrent. Lord Denning also defended the stance of the death penalty, stating that the truth is that some crimes are so outrageous that society insists on adequate punishment because the wrongdoer deserves it. Some cases are so outrageous that irrespective of the value of the death penalty as a deterrent, the great bulk of the community considers that the only fitting penalty is death. It has also long been recognized that a state's criminal policy is formulated rather than determined by dominant social, religious, and political ideas and morals. In Malaysia, support for the penalization of crimes with the death penalty is not unheard of.
For instance, one may look at the crime of corruption for which many have advocated for a death penalty.
This begs the question, if it is arguable for the death penalty to be imposed for corruption, why not in grave cases of incestual rape? And now I shall hand this off to Amir, who will be discussing statutory rape.
Thank you, Audrey. Section 375G stipulates that sexual intercourse with a woman under the age of 16 will amount to rape, irrespective of whether there was consent. In essence, this means that a woman under the age of 16 cannot validly consent to sexual intercourse. This provision presents two main problems. Firstly, the requisite age of consent in the Penal Code is inconsistent with that of the Sexual Offences Against Children Act 2017. Section 14 of the Act stipulates that a person who, for sexual purposes, touches or makes a child touch any part of his body is guilty of sexual assault. A child in this context refers to any person below the age of 18. This inconsistency creates a complicated circumstance, particularly for situations involving women who are over the age of 16 but under that of 18. These women find themselves in a strange situation whereby they may lawfully consent to sexual intercourse, but may not consent to touch or be touched. Though it may be argued that such situations will very rarely arise, the fact remains an unfortunate ambiguity has manifested in law. As such, it is submitted that the age of consent should be standardized across the board so as to avoid confusion. What this age is to be is up to debate. India lists its age of consent at a comparatively high 18, while Singapore has decided upon 14. Whatever age is decided upon, it is submitted that the line drawn in the sand must be one which is consistent so as to remedy ambiguity. Another widely discussed topic regarding statutory rape laws is the implementation of Romeo and Juliet laws. This refers to laws whereby an adolescent girl and an adult man, who is not much older, have consensual sexual intercourse. For example, a situation involving a 15-year-old girl and an 18-year-old boy. Although the 3-year age gap seems significant, it may be that they are merely a young couple in a dating relationship who decide to engage in sexual intercourse. This is known as a Romeo and Juliet circumstance and is arguably very different from what Section 375G presumably intended to cover. Situations whereby an older man takes advantage of young girls in order to have sexual intercourse. However, Section 375G does not differentiate between the two, subjecting them to the same minimum penalty of 10 years and whipping under Section 376D. In the US, 34 states include an age difference clause that allows individuals within certain age ranges to legally consent even if one or both parties are younger than the official age of consent. For instance, in Indiana, consensual sex between adolescents in a dating relationship is not criminalized if they have an age difference of 4 years or less. Such laws protect adolescents in Romeo and Juliet circumstances and prevent like-age teenagers from being prosecuted for normative sexual behavior. In Malaysia, however, stigma surrounding premarital sex is deeply rooted in the societal framework. As such, the implementation of Romeo and Juliet laws will not be without backlash. However, it is argued that young offenders should not be lumped into the same category as sexual predators. As such, it is submitted that these offenders be prosecuted under a different offense with a more lenient sentence. Alternatively, Section 376 should confer judges discretionary sentencing power. This would be similar to the pre-amendment position, but only in relation to Romeo and Juliet cases. Moving on is the issue of consent. In the Penal Code, sexual intercourse amounts to rape if it falls within the 7 circumstances under Section 375. It can thus be seen that the focus here is on whether the present circumstances have occurred within the defined circumstances of Section 375A to G. It is submitted that these specific provisions lead to more confusion than certainty, as cases must fit within the ambit of strictly defined circumstances. This can be contrasted with the position in both England and Wales and Singapore, whereby the main point of focus is the absence of valid consent. It has been argued that there is no need for such specificity, especially when the Penal Code itself provides a general definition for consent in Section 90. Indeed, Section 90 covers most of the circumstances listed in Section 375. However, it is submitted that it does not do so adequately. By reason of it being a general provision under the Penal Code, Section 90 does not cover certain circumstances pertaining to rape, for instance, where a position of authority is used to obtain consent. This was illustrated in the case of Augustine Fung and public prosecutor involving a maid and her employer, and is covered under Section 375F. Therefore, it is submitted that the more appropriate course of action is to amend Section 375 in the following manner. Firstly, the definition of rape under Section 375 should explicitly provide for the element of consent, specifically that rape is non-consensual sexual intercourse. Secondly, circumstances A through G under Section 375 should be deleted. And lastly, that there should be a provision specific only to sexual offences under the Penal Code that lays out the definition of consent. This would mirror the approach taken in the English Sexual Offences Act 2003. There, Section 74 provides that consent is only valid if the parties had the freedom and capacity to make that choice. To illustrate this, cases where consent was provided under duress or where there was an abuse of power would be void for lack of freedom. Furthermore, consent provided under intoxication would be void for lack of capacity. It is ultimately hopeful that this will cover a sufficiently broad set of circumstances without the need for strictly defined compartmentalization within the current law. Now back to you, Florence.
In conclusion, it is submitted that some areas in the law on rape in Malaysia still need to be improved. To summarize it, the proposals for reform are shown in this list. Some of them include substitute the gender-specific language with gender-neutral language, remove the exception to Section 375 so that marital rape can be recognized, age or consent should be consistent between statutes, and the like. And that is all for today. Thank you for tuning in to this channel.